Good evening and welcome to Courts Today by Live Law. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. Starting with a very important update from the Supreme Court, which today pronounced the judgment in the Article 370 case. As you know, a constitution bench heard the petitions challenging abrogation of Article 370 for 16 long days and had reserved the judgment on 5th September this year. The verdict is that the validity of Union Government's 2019 decision to repeal the special status of Jammu and Kashmir under Article 370 of the Constitution has been upheld. The court held that state of J&K had no internal sovereignty and the concurrence of state government was not required to apply the Indian Constitution to the state. That Article 370 was a temporary provision. However, the court left the issue of reorganization of J&K into Union territory open. Further, the reorganization of Ladakh as Union territory was upheld. Significantly, the court also directed that steps shall be taken by the Election Commission of India to conduct elections to the J&K Assembly by September 2024. Further, it stated that restoration of statehood shall take place as soon as possible. The Constitution Bench of the Supreme Court, led by CJI Chandrachud and composed of Justices Sanjay Kishan Kaul, Sanjeev Khanna, B.R. Gawai and Suryakant, pronounced the judgment today. There are 3 judgments in the matter, one by the CJI for himself and for Justices Gawai and Suryakant. The second is concurring opinion authored by Justice S.K. Kaul, and Justice Sanjeev Khanna has concurred with both the judgments. Also, Justice Kaul in his judgment has recommended setting up of a Truth and Reconciliation Commission to investigate and report on the human rights violations carried out by both the state and non-state actors in the Kashmir Valley at least since 1980s. The Supreme Court today heard petitions of Newsclick founder Prabir Purkayas and HR head Amit Chakrabarti challenging their arrests by the Delhi police in a UAPA case over alleged Chinese funding to promote anti-national propaganda. The bench comprising Justices B.R. Gawai, P.S. Narasimha and Prashant Kumar Mishra heard the matter and the hearing was adjourned. Senior advocate Kapil Sibal, appearing for Purkayas, argued that his medical conditions were serious enough to warrant his immediate release. Additional Solicitor General S.V. Raju contended against the bail. Justice Gawai stated that he would have to see if a special bench could be constituted in the case. A special investigation team constituted by the Punjab and Haryana High Court has submitted before it that the 1994 encounter operation in Punjab's Roopnagar district, which claimed to have killed a militant, was stage managed and the FIR was registered by falsifying facts. The petition in this case was filed by the wife and father of the deceased killed in the encounter, seeking transfer of probe of the alleged fake encounter to CBI or any independent agency. They submitted that in 1994, a few policemen came to their house and took the deceased, that is Sukhpal Singh, on pretext of some investigation. They assured that he would be returned the next day, however, he never came back. In the newspaper reports, the police had claimed that a prominent alleged militant, Gurnam Singh, was killed in the encounter. Later, the petitioners discovered that the killing was not of the militant but of Sukhpal Singh and the militant was found alive. It was submitted before the bench of Justice Vinod S. Bhardwaj that the SIT, after taking legal opinion from District Attorney Roopnagar, had registered a fresh case against the then SP of Roopnagar district, the DSP and one ASI. It was also informed that the FIR for offence of murder had been registered against the accused for conducting a fake encounter operation. The Calcutta High Court today heard a plea against author Arundhati Roy for alleged statements made by her to Middle Eastern media house Al Jazeera. The petitioner claimed that Roy had given an interview to Al Jazeera where she had claimed that India was becoming a fascist Hindu enterprise. The petition states that she has millions of followers, that India is one of the only secular countries in the world, yet she has spoken to Al Jazeera and called the Indian government a Hindu fascist enterprise. It also states that the government has the people's mandate and Al Jazeera is a spokesperson of Al-Qaeda of Osama bin Laden. In observing that the plea had not been effectively served on the respondents, a division bench of Chief Justice T.S. Sivangnanam and Justice Hirannamai Bhattacharya directed for it to be listed after service had been effected on the respondents, including X Corp, formerly Twitter. As you know, last week the Lok Sabha had passed a resolution to expel Trinamool Congress MP Mahua Moitra based on the report of Ethics Committee over cash for query complaint. Moitra has been accused of receiving cash in exchange for posing questions on behalf of businessman and friend Darshan Hiranandani. In an interview with the Indian Express, she had accepted the fact that she had provided her parliament login and password details to Hiranandani. However, she had refused the claim of receiving any cash from him. In a new update, she has now approached the Supreme Court challenging her expulsion. Stay tuned for further updates. The District Consumer Disputes Redressal Commission West Godavari in Andhra Pradesh has held Elluru Municipal Corporation and its revenue officer liable for deficiency in service for demanding water tax even after disconnecting the tap supply. The complainant in this case obtained a tap connection in 1979 and had been paying a deposit of 1,000 rupees ever since. Later, due to mixing of drainage water with the tap water, he requested the municipal corporation to disconnect the tap connection. They duly acted on the request and disconnected it in 1996. However, they continued to charge the complainant for water charges and issued 2 to 3 demand notices even after disconnecting the tap connection. Feeling aggrieved, the complainant filed a consumer complaint. The corporation and its revenue officer chose not to file any written version before the district commission. The commission observed that the municipal corporation and its revenue officer were negligent in demanding the water tax even after the supply had been cut off, and that they failed to verify the records and wrongfully demanded the deposit, which constituted a deficiency in service on their part. In another important update, the Patna High Court has said that mere membership in a banned organization should not be reason enough to deny bail, particularly when the trial is anticipated to be prolonged. The division bench of Justices Ashutosh Kumar and Alok Kumar Pandey was hearing a batch of 3 criminal appeals filed under National Investigation Agency Act, where the court granted bail to an advocate accused of the offence of waging war against the government. The accused appellants faced charges of direct association with the Popular Front of India, an organization that had been prohibited in 2022. The court, however, after reviewing all the relevant evidence against the appellant, found it fitting to overturn the contested decision denying bail and ordered the appellant's release on bail provided he furnishes a bail bond. This decision holds significance in light of a verdict by Supreme Court in March this year, wherein it held that mere membership in an unlawful organization would be a UAPA offence. The Karnataka High Court has granted bail to an accused involved in the murder of journalist Gauri Lankesh. The accused was alleged to be harboring 2 other accused who murdered Lankesh by shooting her near her house and being a member of the syndicate involved in committing organized crimes. Journalist and activist Gauri Lankesh was shot dead in front of her residence in South Bengaluru in September 2017. The police have arrested 8 persons in the case. The petitioner was arrested in 2018. It was submitted that the petitioner had been in custody for more than 5 years. The court said that though there are certain rigors for enlarging the accused on bail, the same cannot fetter the powers of the court to enlarge the accused on bail when there is undue delay in trial and the material on record goes to show that the trial may not be completed anytime soon. And lastly, a division bench of Delhi High Court comprising Acting Chief Justice Manmohan and Justice Mini Pushkarna heard a PIL filed by BJP leader and advocate Ashwini Kumar Upadhyay seeking implementation of uniform school syllabus and education board across the country. The plea seeks one nation, one education board. Upadhyay alleged that the bitter truth is that school mafias don't want one nation, one education board. Coaching mafias don't want one nation, one syllabus, and book mafias don't want NCERT books in all the schools. The court questioned as to how the same could be done, keeping in mind different state boards. The court impleaded NCERT in the PIL and sought its response. The matter will now be heard on 14th May. Stay tuned with us. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.